Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a book which has come to us from Edward Elgar Publishing Limited. They're a family firm of publishers. They produce a lot of high quality, high-end academic work. This book is called Business Innovation and the Law, with the subtitle Perspectives from Intellectual Property, Labour, Competition and Corporate Law. It's been edited by Marilyn, Pittard, Anne L. Monotti and John Duns, and we've given it a title, A New and Interdisciplinary Legal Perspective on Business Innovation. My wife Elizabeth and I have reviewed this book in the past, and that's the title we've given it. I'll show you the book very quickly. Nice green cover, front, spine, then the back. Basic information on the back there. The book itself is quite heavy. It's a hardback, and it's there's an index. It's running to 500 pages. There's the index at the back there, and then you've got the normal structure, which is very much in keeping with the house style of Edward Elgar. A lot of detailed footnotes at the bottom, the main body copy, and you've got headings, subheadings and paragraph numbering, but generally just the normal, ordinary numbers that we expect. There's the front page there. Then we get into the main bit. Do read the preface right at the beginning. It sets out what the authors are trying to achieve here. That's part 1, business innovation, part 2, inventions, part 3, employment and labour law perspective, part 4, competition law, part 5, devices to protect business research, part 6, public sector business research, part 7, corporate governance issues. And then we go to the contributors themselves, because this isn't obviously editors looking at a huge amount of contribution. I can't go through all the names because there are a huge number of them, but I'm just showing the names there because these people put a lot of work into producing this book. So I think it's important that people know who's been involved, even though it's a very rushed, and I do apologise, very rushed list. There's the preface there, which has been written by the various professors, and then you go straight into the book itself. You've got a nice little quote at the beginning of some sort, which sets out the theme of the chapter, and then you have the actual body copy itself and some footnotes, and then it runs through, and then for instance chapter 8 is on innovation, and again the same sort of thing. So as I say, it's an interesting book, and this is what we say about it. Recently published by Edward Elgar, this book is a collaborative approach to business innovation and the law. The 24 international contributors, all experts in this field, originally presented their individual research papers at a recent conference in Italy, and it's these presentations upon which the book is based. The subject is nothing if it's not topical, because new technologies, business processes, products and services seem to surface every single day, especially if you watch Click on the BBC. Innovation, say the 3 editors in their thoughtful and information-rich introduction, has been understood to encompass the creation and implementation of new knowledge and invention, and add that most governments in the 21st century link innovation directly with entrepreneurial activity that they assume will deliver economic benefits to society and probably to their bank manager, if I may add that bit. In the light of this assumption then, governments will generally support or encourage investment in research and development, quite often offering tax incentives, and we certainly see that with some of the current policies as we head for the general election in May 2015. Consequently, a wide spectrum of legal disciplines is required to protect innovation and innovators as they set out to market new products and processes in a competitive global economy. Depending on circumstances and perceived consequences, such areas as employment law, labour law, intellectual property, competition and corporate governance, that's company law, will inevitably inform as well as protect innovation. As the editors remind us, this book presents discussion and analysis of approaches to this area of law in Australia, UK, US, also the civil jurisdictions, particularly the European Union ones. And the resulting 28 essays are grouped under 7 categories in different parts, which I showed you. Part 3, for instance, covers employment and labour law perspectives on protecting business research and development, and it tackles the problems of determining ownership of employee inventions. In other words, who owns the invention, the employee who is actually the inventor, or the company who employs him or her. And it's of course not always quite that simple, because quite often the answer boils down to the wording of the employment contract. And of course sometimes people give up their rights. That's the same with copyright, as I'm sure many of you will be aware. Contributors to the book include Jeremiah Prassel and Mark Freeland, both at St John's College, Oxford, among a host of other credentials which I've listed. And they discuss in rigorous detail the limitations of English contract and employment matters. And the chapter on, which is co-edited by Marilyn Pittard, following that particular chapter, examines the issue from the Australian perspective and places the innovative or inventive worker in one of 3 possible categories: genius, accidental inventor, or thief. For further details you need to read the book, but this is a good chapter to read. These of course are only a couple of examples of the insights and the formidable research this book contains. Academics and administrators, as well as intellectual property practitioners and competition and employment laws and civil law and in common law jurisdictions worldwide, or anyone involved professionally in this multifaceted area of law, we think will find this book extremely useful. And the publication is actually cited 2013, and I'm recording this in 2014. That's the book again, nice green cover, as I say. There's the back of it, just opening it in the middle. This is on the long view on competition and mobile employees. You can see again a lot of body copy there, and you've got the footnotes at the bottom. You do have, for instance, this is an Australian perspective from John Dunn's again. You don't have too much by way of paragraph numbering. Some of them like to use a bit of the paragraph numbering, but it's not overused at all. I think it's a lovely book, and I found it very interesting to look at. It's a particularly interesting read if you're involved in this area of civil practice. So can I thank all of the people involved? I'd like to thank Edward Elgar in particular for producing another very high standard of publication, which we of course rely upon as legal practitioners and experts. This sort of contribution is greatly received, so thank you to all concerned. Bye-bye.